All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please call the case.
Good morning. Situation in the Republic of Kenya in the case of the prosecutor versus William Samoei Ruto and Joshua Arap Sang. Case reference ICC 0109-0111, and for the record, we are in open session.
Thank you very much. Appearances, please.
Good morning, Mr. President, Your Honours. Anton Steinberg for the prosecution, and with me Cynthia Tai, Lucio Garcia, Lorenzo Pugliatti, and Grace Go. Thank you.
Thank you very much. Defence.
Mr. President, Your Honours, good morning. Mr. William Ruto is represented by David Hooper of Queen's Counsel, Mr. Essafal and Ms. Sharmila Alagendra of Counsel, and at the back, Ms. Lee Laurie, our legal consultant. Your Honours, my name is Kareem Khan, QC.
Mr. President and Your Honours, my name is Kato Keegan, together with Caroline Buisman, Logan Hambrick, Judy Miongi, and Joel Bosek representing Mr. Sang, who is present.
May it please the President, Your Honours. I'm Wilfred Nderitu, counsel for victims, assisted by Mr. Ochlon Naratsetseg from the OPCV. Thank you.
Thank you very much. We are here to continue with the trial in the case of Ruto and Sang. Mr. Prosecutor, are you ready with your first witness?
I am, Mr. President.
Before we go into the witness testimony, there's some housekeeping matters we need to address. As we all know, last week we did not proceed as we would have liked in terms of calling the witnesses. And the prosecutor had indicated on the record that the reason, or part of the reason why witnesses were unavailable was certain developments in the Kenyan Parliament relating to certain resolution passed. This is something on which we would like some submission. We will take submissions on that matter tomorrow morning. We do that mindful of Article 68(1) of the statute that provides, amongst other things, quote, the court shall take appropriate measures to protect the safety, physical and psychological well-being, dignity and privacy of victims and witnesses, unquote, amongst other things. We will take submissions tomorrow on whether or not the development in question is something that should be taken into account as a factor in the Chamber's measures to, in court, protection measures for witnesses. First, of course, we would need to have the factual matter established on the record, and that's part of the submissions. In that regard, parties should be prepared to address the question, is it a fact that the Parliament of Kenya debated and adopted resolutions that may have any relevance to this case? If so, what? If so, when? If so, why? On the legal submissions, we would like to hear parties on the question, if it is the case that the Parliament of Kenya had adopted any such resolutions, what effect should that development have, either alone or together with any other national or community factor? And evidence of any such community factor must also be provided. In the assessment of witness protection measures in the courtroom, that's the first legal question. And the second one would be, does such a factor override the need for individualized assessment of each witness for purposes of witness protection measures in the courtroom? That would be the second limb of the legal question. So parties should be prepared to address that subject tomorrow.
Mr. President, Your Honours, just a clarification that I seek. In view of the fact that Article 68(1) talks about witnesses and victims, whether it is only the parties that will be making submissions on this or even the victims as participants. Thank you.
That's a very good question, Mr. Indiretu. I did not mean at all to exclude you from the submissions. You will be making submissions as well.
I'm much obliged.
Mr. President, Your Honours, of course we'll make those submissions tomorrow, but it's not clear, perhaps I've missed something in the transcript. The why, of course, is for the Kenyan Parliament. Are Your Honours asking also for submissions as to what, if any, effect such a resolution may have? Because, Your Honours, the simple reality is Kenya is a state party, and all the measures and the cooperation that was extended by the Republic of Kenya that existed before the vote continues today. And so, Your Honour, the more pertinent question with respect, and perhaps it's been included, is what, if any, effect that could possibly have on these proceedings. But, Your Honours, I can't possibly, and I'll give advance notice, go into the whys of the Kenyan Parliament, which is, of course, a sovereign institution made up of democratically elected individuals. What I can talk about is the legal consequence, if any, of such a resolution.
Mr. Khan, I hear you, and the question, if you remember, is in the context of in-court witness protection measures, not any broader question.
I'm grateful.
So that will be the map of the submission we expect on the matter tomorrow. For purposes, again, I stress that what measures need to be taken to protect witnesses in the courtroom. Now, moving now to the matter of the day, which is the calling of the first witness for the prosecution. A few things need to be clarified again in that regard. In the Chamber's decision number 2 on the conduct of proceedings, general directions, a quantum of time was allocated for the case, for the prosecution. That quantum of time was derived from a formula that on the basis of an average of 4 hours per witness. It needs to be stressed that the purpose of that formula was not at all to require the prosecution in every case to limit its examination of its witnesses to only 4 hours. The 4 hours was, as I said, merely a formula to arrive at an overall amount of time to be allotted for the case for the prosecution. Of course, what that means is it's up to the prosecution how it uses its quantum of time. If, for instance, let's say 2 witnesses are called and are lined up, it is up to the prosecutor to decide whether to ask them 4 hours, to use 4 hours per witness, or 5 for one, 3 for the other, or 7 for one, 1 for the other, or even 8 hours to one witness and decide not to ask the next one any question. So that is left for the prosecution. That needs to be stated clearly before we proceed. Now, the witness we're going to listen to next, prosecutor, can you indicate who?
Thank you, Your Honor. It is witness P0536.
Thank you. This witness, so it is understood, has been assessed by the chamber and found to deserve protection measures in the courtroom that will require that her identity not be revealed to the public in terms of both her face or her voice. That measure has been granted. The chamber has also considered the need to permit, on the recommendation of the victims and witnesses unit, that the witness have sitting with her during her testimony an assistant from the VWU, and that request is also, that recommendation is accepted by the court, and that we will proceed in that manner. I think we're now ready for the first witness. I see Mr. Director.
Yes, Mr. President, I'm on my feet now. To just mention that pursuant to the order that was granted last Friday, I did proceed on Saturday to interview the witness who's just about to come and testify. And thereafter, I did transcribe the statement that I had with her. But most unfortunately, in view of the fact that yesterday was not a working day, I have not been so far able to upload the statement through CMS as required by the e-court protocol. As such, the statement is yet to be disclosed to the parties. But that is the statement in connection with her status as a victim, rather than the statement that she has previously given and which have already been disclosed. I am seeking your guidance on that.
Mr. Gann.
Your Honour, sometimes there are these technical glitches, and when there are, perhaps the old-fashioned way is best if the statement can simply be printed out and handed over to us, and then it needn't delay proceedings. We can read it whilst the examination in chief is ongoing. But if it can be given by the first break, by the end of the first break, it would be appreciated.
Mr. Keegan-Cartwell.
That's agreeable to me also, Mr. President.
Yes.
Ruto, I take it that should be acceptable to you?
That should be acceptable. And in fact, I have a few copies here, which I could perhaps hand over even now if that was to be accepted.
I think you can arrange with the court usher to do that while we proceed with the rest of the business. Thank you. With that out of the way, we will now receive the witness. Mr. Court Officer, I believe that we will require to go into closed session in order to enable the witness come into the courtroom. But before we do that, just one more minute. There was an indication earlier about the use of the protected it was not an indication on the record, but we were informed outside of court that there may be some questions relating to the use of the protected information sheet PIS. Is that the case?
Yes, Your Honor, that is the case. We have taken the court's lead in this matter and prepared only one, on which we have listed all of the relatives of the witness to whom she is likely to refer during the course of her testimony, which would then permit us or enable us not to have to go into private session every time she wanted to refer to one of these people, which would be fairly frequent. Nevertheless, I do anticipate that we will need hopefully not more than 3 private sessions during the course of her testimony. The first one being at the beginning when I deal with some background and personal information, and the other two relating to matters which would also tend to identify or disclose her identity to those listening.
The purpose of the PIS is to eliminate, as we indicated earlier, frequent going into closed or private sessions so that members of the public can be a part of it. But as often happens in these things, there are times when it is simply inevitable that private or closed sessions must be used. In that case, we just proceed in that way for the limited need of such confidential information being discussed on the record. Matter now is, if you do envisage going into private session, it may be best to deal with what you may have in your PIS now during the private session, so that private PIS remains for where a witness is testifying at large and may need 1 or 2 instances of reference to 1 or 2 discrete items of confidential information that we use PIS to do that. But if we do contemplate large swaths of testimony in private session, it may be more efficient to use private session to discuss such matters as you would ordinarily, in those sort of situations, put in the PIS. Is that clear?
That is clear, Your Honor. Thank you. And perhaps I can just clarify that I do intend to go through with the witness in the first private session the details relating to her various relatives. But I foresee that during the course of the evidence from time to time, as she gives her narrative of the events of the day in question, she will refer to the fact that she had a certain child with her or she had a certain other relative with her. And what I propose is that she will then refer to the person as person number 1 or person number 4, child number 5, child number 6, child number 8. That's what I had in mind.
That's acceptable to the chamber then.
Thank you, Your Honor.
With that then cleared up, court officer, we may proceed to into the closed session for purposes of inviting the witness into the courtroom. Thank you.